Thank you for everyone for joining us. I'm Alfred Sanchez. I'm the president and CEO of the Greater Miami Chamber of Commerce, and welcome to another one of our Thursday Chamber Roundtables. Today, we're going to be focusing on COVID-19 and basically the second part to our focus on labor and employment issues involved in the reopening of our businesses and our economy. Today's session is being presented by our HR committee, led by Elpanye K. Hudson. We lovingly refer to her as EK, and Patrick Martin, the chair and vice chairs of our HR committee. Thank you both for putting this together for us. Many important topics are going to be presented today, including the health and safety of the workplace, general protocols, addressing employees refusing to go back to work, all the kind of things like updating your handbook and rehiring protocols. There's so many things that have to change with this new normal that we're living in that keeps constantly fluctuating back and forth. So I think it's extremely salient discussion. Now, as the feature of all of our Thursday roundtables is that we really want to focus on your questions. And in order to do so, we have done it in a way to maximize the efficiency. As you'll notice, all of your microphones are muted. We are having the chat box there for everyone to, socialize and connect with one another. Also, if you have a clarifying question. But if you want to ask the panel a question about the topic, you need to use the Q&A form, which is down at the bottom. Go in there, open it up, type your question in, and I've got folks in the behind the scenes here who are feeding those questions to our moderator and our host. But please be aware that unless you ask your question in the Q&A, it will not be answered by the panel. So make sure to use it and engage in the chat if you want to. And it's part of being a chamber member. It's my pleasure now to introduce the chair of our HR Professional Development Committee, Elpanye E.K. Hudson. She's been a part of the HR industry for almost 30 years. She's Vice President of Human Resources for FIU, and she's responsible in her role for basically the strategic innovation of the Division of Human Resources. And she oversees all 12 discipline-specific areas of HR, including employee and labor relations, employee management initiatives, and the Office of Inclusion, Diversity, Equity, and Access. In addition to managing an $800 million payroll, just a little bit bigger than ours, EK also exercises fiduciary responsibility, managing a $30 million operating budget. Here's a woman who has an incredible amount of experience and an incredible heart and love for HR and the employee. Let me introduce to you our moderator, EK Hudson.
Thank you. Thank you so much, Alfred, and good afternoon, everyone. Welcome, welcome, welcome. We really appreciate you, Alfred, and thank you so much for your leadership and support, and to all of you that have taken time to join us. If you have ever attended an HR and professional development event, virtually or in person, we value your time. You know that. And so we want to make sure that today's event is no different. You can expect excellence as you always receive. We have a power-packed panel ready to jump right into this great discussion on legal and employment issues, on reopening the workplace. And I tell you, it's a place we're all walking through. I don't know that in my lifetime I've ever experienced a 4-month stint like we have now. But I'm grateful. I'm grateful that we're here. I'm grateful that we're able to share some of the things that we'll be talking with you all about today. I want to echo Alfred's sentiments. Please, please, please use the chat box for comments and exchanging ideas. That's one of the fun parts. We don't get to have a social reception prior to, so we want you to use that platform to share ideas and information, and then place your questions in the Q&A area so we can answer them and share in that fashion as well. The webinar is being recorded. I want you to be aware of that, and it will be available on the Chamber site later today. So with that, let me just go right ahead and introduce these distinguished comrades I have that'll be sharing with us this afternoon. And I'll begin with our Vice Chair of the HR and Professional Development Committee, Patrick Martin, who's a partner at Greenberg Traurig, focusing his practice on employment law matters, representing employers of all sizes before state and federal courts, as well as administrative agencies such as the Department of Labor, the Equal Employment Opportunity Commission, and the Florida Commission on Human Relations. His presentation will be followed by Aaron Tandy. He's a partner with Pathman Lewis, and he heads the employment law section. He places a special focus on resolution of business torts, regulatory and administrative hearings, employment and HR litigation, and e-commerce and intellectual property disputes, including the gathering and proper use of electronic and social media evidence. And lastly, but definitely not least, you'll hear from Michael Mueller, who is a litigation partner at the firm of Hunton, Andrews, and Kurth, where he is based here in Miami as well as in Washington, D.C. He has 33 years of experience with labor and employment cases, including more than 60 private class actions involving claims under the Federal Fair Labor Standards Act. And when those distinguished gentlemen are done, I will come back and share with you some things that are from an HR perspective, but we'll pull it all together and have a dialogue around. So with that, allow me to turn it over to you, Patrick. Your microphone is muted, Patrick.
How about now?
Perfect.
Thank you, everybody. Welcome. Hopefully we'll be able to give you some good and valuable information on this very important topic now that we have many businesses reopening and having employees return back to the office. I'm going to focus my time on some of the changes, possible changes to your employee handbook and other policies as employees are returning to work, and then also some of the discrimination issues that you should be aware of as they relate to specific decisions that are made as employees are returning to work. Now, mind you, what I'm going to be talking about today in terms of handbooks and policies and written policies, but they're all subject also to the extent that you are governed by a collective bargaining agreement. So obviously you would want to consult that agreement to make sure that it's not something that you have to consult with the other side on. But most of us live with these handbooks, right, without the collective bargaining agreement. And one thing that we're all going to have to take a look at are our sick leave and PTO policies. Obviously, the Families First Act mandated employers provide paid sick leave. And as Mike will discuss, there are a lot of nuances to the requirements of that particular law and the required paid leave that's being governed to employees. I don't necessarily advise that you amend your handbooks to include all of those requirements, but it is certainly something to consider, perhaps in an addendum to your handbook, because there are a lot to go through, and certainly you want to put your employees on notice of these requirements, but it also serves as a cheat sheet for HR going forward. For example, I have received a lot of questions about mandating the use of PTO concurrently with the extended FMLA leave. And that is something that, again, would require all of us to sort of look at the regulations put out by the DOL, because these things are constantly changing. And we do know, for example, that you can't do so with employee sick leave. So that's just an example of something that you might need to go back to your handbooks to take a look at in terms of any policies that mandate the use of PTO concurrently with FMLA leave. It might be strange to think about vacation time, but when everyone is starting to come back to work, but people still need a break. There aren't many options for a lot of those kids who are out of school, and so one thing you want to think about is sitting down and really thinking about how you're going to handle those vacation requests before they start to roll in, so that you have a nice, consistent application of those policies. Stephanie, I didn't ask you to move forward my PowerPoint. Sorry, can you? There we go. One more. Next. Another thing to take a look at is our remote telework policies. There are a lot of companies before that had automatic across the board prohibitions against these things. And with how companies have adapted to a lot of employees working from home, it's time to rethink those policies. Here at our firm, for example, you know, there was a lot of resistance to having people permanently being able to work from home, but we've seen through this a lot of high productivity numbers coming from individuals who have been working from home. And so at this point, I think it's going to be really hard to say no, or to have an automatic no to any teleworking. And just like anything else, working from home is going to be something that needs to be managed just like any other job performance issue. And that's especially true in the context of accommodations under the ADA. I mean, unless you're a chef or something similar, it's going to be very difficult to continue to make the argument that allowing someone to work from home is an unreasonable accommodation request. Next slide, please. One of the other things that we see come up also are travel policies. You know, we might be returning to work, but as Aaron will discuss, there are a lot of safety protocols that we have to bring to face in bringing back employees. And one of those should be how you handle business travel. I mean, it's hard to say it these days what specific spots should be currently avoided. Heck, with the numbers that we've been seeing in Florida, you know, Florida might be on that list at this point. And so, you know, you should include the review of travel requests and, you know, in business travel, include that as part of your protocols that you're adopting as employees are returning to work. You know, nothing prevents a company from questioning employees about their travel, and that applies both in terms of the business and personal travel. You know, and these questions might bring up the need to quarantine upon their return. Just obviously be mindful that any inquiries that you're making be within the CDC guidelines and not based on any sort of personal assumptions. Next slide, please. Job descriptions is something else to take a look at. I think with a lot of employees working from home and companies having to adjust and make do with what they have and not having everyone available, I've had a lot of clients reevaluate certain jobs and what they need performed in those positions. And a lot of that reevaluation occurred on the fly. Now that everyone's coming back to the office, it's really time to sort of write that down and memorialize those changes, because we know job descriptions are really important in managing performance and really important in evaluating future accommodation requests. And usually that's the first step that we take a look at. Next slide. Expense reimbursement policies, you might come into this issue as well when you're talking about having to reimburse for protective gear or reimburse individuals or employees for expenses that related to them working from home. You know, companies are going to be requiring various, you know, some companies may require more than just masks, but remember, the cost of equipment or the cost of things that are needed to do the job can't take anyone below minimum wage. And so you want to make sure that your reimbursement policies reflect the ability to do so for some of these business expenses. Next slide is training. You know, you're going to hear a lot in terms of new rules and requirements, all geared to making people feel comfortable to come back to work, making the workplace safe and healthy from COVID-19. And it's a good idea to reinforce those rules with training materials. You want everyone on board on the same plane, so to speak, in terms of making sure that the importance of maintaining these measures are spread to everyone in the company. And so it's a good idea to reinforce that with training. It's also a good idea to reinforce training on some issues that have already been they've already received training on, like again, against using certain stereotypes and assumptions when dealing with coworkers. I mean, there are a lot of issues just related to COVID-19 in terms of older workers or the national origin of certain workers. And these are kinds of topics in terms of examples that you can use from COVID-19 to retrain everyone on some of those issues. And let's face it, we're not just coming back from COVID-19 pandemic, but we're also coming back from a really big social justice movement that's caught the entire nation as well. And you know, this might be outside the purview of what we're talking about here today, but this is another example in which we're going to see a lot of dialogue and continued protests as we come back to work. And I think it's a good idea to confront those issues in the workplace with more training to ensure not only a healthy workplace, but also one that's free of harassment. Next slide. Posters is something else to think about. I think with a lot of people working from home, you know, while our physical locations were all closed during the pandemic, a lot of these things got emailed to employees. The information was emailed sent to them electronically. And so this is a good reminder to physically post those posters at the workplace now that they're reopening, so that they're there and you meet the requirements. Another thing to think about, next slide please, is notice to the employees about changes to the terms and conditions of their employment. And it might be something where you send them essentially another offer letter. To the extent changes are made, you want that memorialized, because obviously you want notice to be given to employees, especially when you're talking about changes to their compensation, but also changes to the hours or any other employment terms. Establishing like a date of return. And, you know, some of these, you have a list there, but, you know, one of the things that you might not occur to you is I-9 compliance. I think during the pandemic, there was an exception made in terms of the actual physical review of these documents. But once they return to work, there's going to be a requirement that you do conduct that physical review. You might need to have employees re-sign their restrictive covenants and reconfirm their commitments and obligations to those agreements. Or it might just be a reconfirmation of previous terms, and so even if there were no changes. You also want to take a look at employment agreements and any equity agreements to see if there are any changes needed there, or whatever it is that's mandated by those agreements. Next slide. There's also benefit implications. You know, we could spend some time, but I'm just alerting to some of the issues, sort of issue spotting. But you know, some plan documents might allow for the permissible election of benefits. There might be a lifetime or a life occurring change that would allow those types of changes. And you also want to take a look at your 401k plans, because certainly there's a threshold in terms of number of employees that might be impacted depending on how many are coming back. So those are some of the, next slide. So those are some of the handbook policies or whatever written policies that your company has that you want to take a look at. But I also want to touch on some of the discrimination issues that you want to be mindful as people return. Next slide, please. Now, a lot of companies are not necessarily doing an across-the-board return of all of their employees, and they're actually making selections or selecting groups of employees or individual employees to come and telling others that they're not ready for them to come back or they're not being brought back. We've already seen rumblings from certain groups that some other groups are being favored when selecting who it is that's coming back to work. And so to avoid any sort of discrimination claims, you want to be sure to really evaluate the decisions that you're making and bringing certain groups of individuals or certain individuals back to the workforce. One thing to first take a look at is, once you've decided, are those decisions disproportionately affecting certain groups? You want to, in essence, conduct a disparate impact analysis. But the best way to avoid risk in this area is to really use like a neutral criteria when you're deciding if someone's coming back to work. Like, for example, tenure is a pretty objective criteria that you can use. But frankly, we know, practically speaking, a lot of employers are taking the opportunity to use job performance and perhaps get rid of certain non-performing employees. Here, you want to be very careful because we're talking about subjective criteria. And so if it is based on a performance issue, you want to look and tie those decisions to their past performance ratings. Well, the last thing you want to do is say this person's a poor performer, and then we look at their reviews and that doesn't simply, they don't simply support the determination that they're a poor performer. Remember, it's always a bad omen if an employee is being given written notice of bad job performance for the first time after an adverse employment action has been taken against them. Next slide. one thing to keep an eye out for as well is religious accommodation. You know, certain screening methods that are being employed, for example, may require a review by some sort of screener. Some religions may require that be done by a person of the same gender, or the wearing of certain protective gear might interfere with various religious garb. And so we need to be mindful of the need to accommodate those issues as they come up as well. Another, you know, in terms of discrimination issues is age. I've had a number of clients who really coming from a good place are worried about older workers because of the fact that they're in that zone of danger when it comes to COVID-19. But, you know, the EOC has clearly come out, and it's intuitive to think that you can't preemptively tell older workers they can't come back because of that. You can't just involuntarily exclude everyone just based on the fact that of their age. That would be in violation of the ADEA. You know, obviously there's no duty to accommodate someone because of their age, but at the end of the day, you know, certainly has been my advice to look into accommodations that would allow someone who is worried about coming because of their age, allowing them to continue to work through, again, teleworking or whatever other methods there might be. Next slide. Pregnancy discrimination, obviously there is a duty here, just like under the disability, under the ADA, to accommodate someone who's pregnant to the same extent that you would accommodate any other person with a short-term condition as that. And you can't, again here, you can't play the role of benevolent employer, right? So we've seen, even before COVID-19, we were aware that you can't just, in terms of looking out for a pregnant employee, keep them from being able to do their job, if just based on an assumption that you're trying to look out for them. Same thing applies with COVID-19. You can't exclude someone out of concern of the fact that they're pregnancy just because they're pregnant, and that you really need to evaluate the particular situation before you make any sort of decision where you're in essence telling someone they can't come back to the office. National origin discrimination, I think this is a big area that provides an opportunity for training. You know, you be aware of harassment of Asian employees, for example. There can't be assumptions. You know, be aware of any sort of stereotypes or assumptions amongst your workforce, or even just the kidding around. It could be electronically. It can obviously be the traditional sort of harassment allegations that you see in the workplace. But again, you know, you just want to remind everyone about what they've been trained on before, possibly train them again anew when they do come back to the office. And certainly it's always helpful to put out there your open door policies and making sure that there's a place for employees to feel comfortable about raising particular issues that come up. And lastly, we want to talk about, just in terms of issue for gender discrimination, could be in terms of how you treat certain requests for childcare. Just because, again, you can't use a general stereotype or assumption in terms of who is taking care of the children. And so you can't treat certain accommodation requests more favorably depending on the gender of the person who's asking. And that certainly can lead to issues that would lead to a discrimination claim. So those were the issues. Again, it's just an overview of a lot of issues to think about as employees are returning to work, both in terms of potential risks, but also in terms of proactive things that you can take a look at in terms of your policies and your HR mandates in the company. And now I'm going to turn it over to Aaron, and he's going to talk about some of the precautions that everyone is taking a look at as employees are coming back. Thank you, everybody.
Thank you very much, Patrick. So I'm going to cover in brief the issues that are presented under the Americans with Disability Act and the OSHA, Occupational Safety and Health Administration guidance. I will say up front, this guidance is changing weekly. So what we say today is the best information we have today, but the ADA, the EOC recently updated, as of last week, the ADA guidance. and OSHA recently updated last week their guidance. So this is something that's changing as more information comes available. And so much of what we're going to talk about is sort of in general. So we can go to the next slide if we can. So as Patrick mentioned, just because we have a COVID-19 situation, it doesn't mean that the discrimination laws, the ADA, the Rehabilitation Act, all of that legal soup, as we call it, the various ADEA laws don't apply. So as you are dealing with reopening your offices, you have to make sure that you are still following the laws on the books. They haven't been suspended with regards to the Americans with Disability Act, with regards to OSHA. So obviously, the importance is both the EEOC and OSHA are also following CDC guidelines. So to the extent that the CDC indicates that there's going to be changes that they're suggesting people undertake, those will then be incorporated by the EEOC and the OSHA administration into their accommodations. So be aware to be, thoughtful, but also there are multiple places where you're going to need to ask for some assistance, some of which we put up on these slides. So let's go ahead and get into it. So the EEOC guidance regarding the ADA is in a very interesting document, which says what you should know about COVID-19 and ADA Rehabilitation Act and other EEO laws. It's nice that they actually made it very simple. That is up on the EEOC website. That publication helps you to determine the issue about how to do disability-related inquiries and medical exams, how to keep medical information confidential, hiring, as well as what we call onboarding, which is maybe re-bringing people back to the office, how to deal with reasonable accommodations, and how we address pandemic-related harassment. And all of the stuff that the EEOC is doing is also taking into consideration the way that OSHA requires that an employer be responsible for providing a safe workplace, which means that OSHA has mandated that employers are responsible for not only making sure that the employer cleans the office space or the workspace, but also that employees are provided with gear, personal protective equipment if necessary, but also cleaning supplies or reimbursed for those cleaning supplies to do so. So I want to say, when we were gathering for this, there's a question as to whether or not healthcare screenings, which are allowed, right? Taking people's temperature checks, asking people about how they're feeling that day, whether they've been exposed or potentially exposed to somebody who may be diagnosed with COVID-19 before allowing them back into the workplace. Is that compensable time? For best we can tell, and again, there hasn't been direct guidance on this, that time is probably not compensable because it probably falls under what we call security checks. And the courts have determined that employers who engage in having their employees engage in security checks prior to coming on the premises that's not compensable time. On the other hand, right, so the question's about, if I put on a mask to come to work, do I start my clock when I put on the mask? Probably not, because obviously here in Miami-Dade County, the county is requiring that whenever you're not in your car or in your home, that you have a mask on. So that's not necessarily work related. However, at the end of your shift, if you have your employees clean their workspace, clean down their phones, clean down their desks, engage in any other cleanup activity, that would be compensable time. And so as you're deciding when the workday is going to end, you may need to build in time for that. In addition, OSHA has suggested that employers require sort of what we'll call general common sense infectious disease prevention matters, meaning They've suggested that employers make sanitizer available and that there be a schedule for employees to utilize that sanitizer. In my office, at every copy station, we have a bottle of sanitizer so that when somebody's done using the machine, they can wash their hands. We've also engaged in periodic, scheduled hand washing with soap, again, provided by the employer. And that's something that that OSHA says people should do. And in addition, obviously providing some type of wipes to wipe down equipment that people may be sharing is important to prevent the transmission. Go ahead and go to the next slide first, okay? So we were just talking about this. Normally, the ADA does not allow employers to require employees to undergo medical examinations or testing prior to coming into the workplace. However, the EEOC has made an exception for COVID-19 medical inquiries and medical screening, as well as allowing employers to mandate that employees who are returning to work take periodic viral tests. For those of you who may be aware of this, the viral test is obviously a nasal swab. I've undergone it. Requiring people periodically to do that apparently does not violate the ADA. However, the EEOC has been very clear that requiring anybody to take the antibody test, which requires them to provide blood or other fluids or samples, is medical screening, which is not permitted under the ADA. So as a practical matter, as I've noted, it's okay for an employer to conduct daily temperature checks, turning away employees whose temperature is too high. This is one of those situations in which you as the employer are required to, because you're providing a safe workplace, set a guideline. So if somebody says, I normally run a fever during the day, why can't I come to work? If you've said if you're 95.5 and above or 100 degrees and above, you're not being allowed to come in. As long as you're not making exceptions, so you avoid some of the discriminatory issues that Patrick identified, that's okay. You can also keep the screening tests, both the questions and the results, but to the extent that you retain that information, the ADA and OSHA requires that you keep that information confidential. So that means that you cannot put that information in the employee personnel file, and it also means that it can't be disseminated to everybody. So if you took everybody's temperature check, you can't send an email that says, everybody who came in today passed the temperature check. Everybody can sort of assume that by common sense, but you as the employer are not allowed to divulge the results of the tests that you've asked for. Similarly, if you send somebody home, you as an employer are not permitted to let the rest of the workspace know that you've sent somebody home because they may have failed some portion of the screening test, whether it be temperature or some question. People can decide on their own, common sense, something must have happened, but you're not required to do so. Or actually you shouldn't, in order to avoid violating the ADA confidentiality rules. We can go to the next slide. So I understand there was a question I saw in the chat, so I'm going to try to use that to answer the question. Somebody asked the question, they have an older worker who has requested an accommodation, I assume, to work remotely because they have a healthcare condition, but they're an essential worker and requiring them to work from home would be a hardship on the business. So how does that work? So Under the ADA, those of us who work in the HR know, you cannot simply assume that somebody needs an accommodation, right? So just because you know that there was an employee last year who had treatment for cancer, you can't say, I'm going to, on my own, give them an accommodation and let them work from home. The employee has to request the accommodation. When the employee requests the accommodation under the ADA, then the employer is required to engage in an evaluation as to whether or not an accommodation can be made that doesn't pose a undue hardship or significant difficulty for the business. Okay? You can voluntarily provide an accommodation, but you can't mandate that an employee take the accommodation unless they've requested one. So how does that work? Meaning, if you've decided that you're going to allow people, as Patrick's office has, to telecommute, for some people that might be an accommodation. But since you're offering it to a broad swath of people, you can do that voluntarily without individually going to each employee and determining whether they needed that accommodation. On the other hand, if a person comes and asks for an accommodation, the employer is only required, even under COVID-19, to provide accommodation that is not an undue hardship or significantly difficult. So what does that mean in terms of the question that was asked? Older worker needs an accommodation. So what could that accommodation be other than working from home? So what it might mean is that if the older worker is not going to be able to take public transportation, you as the employer may be paying or providing transportation. That would be an accommodation, right? While the person's in the office, you may make it clear that they are isolated. So you can set them up in an office in which nobody comes in and nobody is allowed to come in. And in order for their health, they simply are left alone while they're in their office to do their job. If that's an accommodation that can be made, right? So that's a different accommodation than working from home. You're isolating the person. So that's one of the things that you might be able to do. On the other hand, say for example, you're an airline and you have a pilot who says, I want to work from home and I can do other things other than fly a plane, but I need that accommodation. If that presents an undue hardship, or it's significantly difficult because that would displace somebody else from doing that job, and you hired them to be a pilot and they can no longer perform that job, you don't have to offer them the accommodation they've requested, right? So I don't know if that answers all of the questions, but that's one of those things. Remember, the ADA does not require the employer to accommodate an employee without a disability based on the disability-related needs of a family member. And nothing that the EEOC or the Department of Labor has said has changed that. Meaning, if I have an older worker who's in good health, who hasn't requested an accommodation, but you know that they're living with a family member who themselves has a respiratory condition, you're not required to offer them, even if they request, an accommodation under the ADA because they're concerned about bringing something back from the workplace that might affect their family member. I know that sounds, I don't want to say cruel, but that's the way the law works. The ADA is designed for an accommodation for the employer and employee relationship, not the family relationship. Now, that doesn't mean that the employee may not be able to take family medical leave time if you're a big enough employer to care for their relative. whether paid or unpaid. And as part of that FMLA leave, you may decide voluntarily to engage in some alteration of their job title or their job duties or the way in which they perform their job, similar to what Patrick talked about in terms of being flexible. But under the ADA, you're not required to do that. So let's talk about, for a second, OSHA. So OSHA has issued 2 publications. They're up there. One is about preparing the workplace for COVID, and one is about returning. Obviously, OSHA said these are only guidance documents. They're not intended to make new law, but OSHA has issued several enforcement memoranda that you should be aware of. So what does that mean? So OSHA currently has a time frame for you to, as an employer, to provide information to OSHA about any fatality in the workplace or a fatality caused by the workplace or any illness that results in a hospitalization or quarantine. That already exists. The question you have to ask with COVID is the, unfortunately, fatality or the illness something that occurred in the workplace? And if so, it's a reportable issue. And if not, then it's not. So for example, the timeframes are simple. If there is a workplace fatality, you have 8 hours to inform OSHA. If you have a hospitalization of an employee from the workplace, or which you suspect was caused from the workplace, or a quarantine situation caused from the workplace, then you have 24 hours to notify OSHA, and you have to put it on your log. So how do you determine whether or not something's work-related, right? People get COVID from a variety of places. People go out, and unfortunately here in Florida, people are going out mostly without masks and encountering, oftentimes leading to COVID related diagnosis. So how do you determine? Well, OSHA has a set of principled ideas, obviously, that you have to engage in. One is, are multiple employees testing positive for COVID? If they are, then OSHA makes the assumption that at least one of those exposures was work-related. The idea being, even if you can't do trace contacting, somebody actually brought it into the workplace and then infected other people in the workplace. And if that happens, then you need to identify to OSHA that you have a workplace issue within 24 hours, and obviously engage in quarantining those people who have been diagnosed with COVID and the people, it's very important, and the people they've come in contact with. I know I'm running a little long, so I'm going to try to speed up, but remember, OSHA has indicated, we can go to the next slide. We can go to the next slide. The cleaning. OSHA has indicated that there is no substitute for making people, even in the workplace, wear a mask. So just because OSHA says one of the key elements to any business plan, reopening plan, has to be social distancing. Isolating the people that you're allowing back in, avoiding in-person meetings to the best you can, and making sure that you engage in proactive cleaning. Your workspace, the common areas, all of the like. If you do that and you document it, then OSHA will assume that if there is a one-off COVID, one of your employees tests positive for COVID, that the exposure did not occur in the workplace. Okay. However, if you have two, OSHA is going to require you to investigate as to whether or not, right, two or more, whether or not one of those exposures occurred in the office. And if it did, then take precaution. I will also say, before I sort of end, which is OSHA requires that if somebody tests positive, whether they test positive because of a workplace exposure or they test positive because of a personal exposure, that you as the employer have to notify the coworkers they came in contact with, and if necessary, quarantine those employees for at least 14 days. And again, you can require them to get tested, not the viral test, not the antibody test, but the viral test, to determine whether or not it is safe to let them back into the workplace. I think I've reached pretty much the end of my time. Before I turn this over to Michael, I do want to say one last thing. We can go to the last slide, I think, which is this. We were talking about this before, and we've all got questions about this. What happens if I have an employee who says, I just don't feel comfortable coming back to the office? They haven't tested positive for COVID. They haven't indicated that they've been exposed to somebody who has COVID. They're just concerned about coming back to the office. In that situation, it is important that you run through the sort of checklist, the soup. Are they covered by the ADA? Are they covered by emergency paid sick leave? Are they covered by the Emergency Family Medical Leave Act? Are they covered by traditional FMLA? Does the OSHA requirements, so that you may not be able to isolate them in your office space because of the way that you work, right? We have the case of the McDonald's worker who sued, claiming that they were exposed to COVID because there was no way for them to social distance in the McDonald's in Chicago where they were. If all of those things are negative, right? If none of those things apply and the person decides they don't want to come into the office and you're requiring them to do so, then it is more likely than not, you're going to be able to terminate that person for job abandonment, right? Because if you're not required to provide them with an accommodation under the ADA or some other requirement by OSHA, their failure to come in when you've reopened the office is basically just like somebody else who's not showing up for a shift. With that, I'm here to answer questions, as is Patrick and Alpania and Michael, but I'll turn it over to Michael for his part of the presentation.
Thank you, Aaron. Appreciate that. This is a supplement to the presentation I gave on April 7th on the Families First Coronavirus Response Act, which is abbreviated FFCRA, which amends provisions of the Fair Labor Standards Act to provide for emergency paid sick leave, along with amends the FMLA to provide a type of expanded or extended FMLA. So there's two types of sick leaves available under the FFCRA. We did a whole program on this on April 7th. For those of you who did not attend that, I would encourage you to take a look at that. I'm not going to repeat that, but just for your convenience, the first two slides of my deck, I'll just go through those real quick. Just show the next one also. These first two slides, which I won't cover right now, explain basically what types of businesses are covered by the statute. It's basically employers under 500 employees, and then there's a small business exemption. It's not automatic, but you can claim it under certain circumstances if you have less than 50 employees. So I'm just going to assume familiarity with that, and then I'm going to go on into an update of the FFCRA. So when I talk about an update, I'm talking about what the Department of Labor has done to provide new guidance since our webinar on April 7th. At the time of the webinar we did previously, there were 79 FAQs where the Department of Labor tried to spell out in plain English those things that they thought would be most of interest to HR, personnel, and employers generally about how to comply with the statute. So I'm not going to cover the first 79. I tried to cover those generally in the April 7th presentation. But starting on April 10th, right after our last seminar, they issued another 14 frequently asked questions and answers that I think provide some helpful guidance. And I want to just cover those briefly here before I move on to some other issues, which is the work callback and non-discrimination principles. Let's start with just the highlights, and I'm not going to cover them all. In FAQs 80 and 81, the Department of Labor addresses how to calculate leave pay for employees with irregular hours. There is a lengthy discussion there of the examples, so I will not try to summarize all that here, but the general rule is that the employer must pay for each day of leave based on the number of hours the employee would normally have worked that day for a 2-week period up to 80 hours. So that's the first point. The next bullet is a summary of FAQs 82, 83, and 85. And by the way, when I talk about FAQs, there's a link at the end of this presentation to the Department of Labor website that has these 93 commonly asked questions and answers. In 82, 83, and 85, the Department of Labor talks about how to calculate the regular rate during paid leave under the FFCRA. Again, the FAQs are very long. They include a chart on non-excludable remuneration that must be taken into account in calculating the regular rate. But the general rule is to calculate the regular rate over the full work weeks during the 6-month period before the employee's first day of paid leave is taken. And then if the employee takes leave intermittently, that is on and off between now and the end of the year when the statute expires, the period used is still always the 6-month period before the first day leave was taken by the employee. The next bullet is, stay on the same slide. FAQ 86 makes clear that, and this is a point I talked about on April 7th, that the emergency paid sick leave is in addition to any other leave that may be provided for by law, local ordinances, the employer's policy, or collective bargaining agreement. The employer cannot require the employee to take both leaves concurrently, but the employer and the employee can agree to combine them in weeks 3 through 12 to top off the employee so they get 100% of their pay. And if you look at the FAQ, this one's a kind of a muddled mess, but it addresses what I just summarized there. Next bullet is FAQ 87. Clarifies something that I think the lawyers were advising their clients about previously. The statute was written in terms of isolation and quarantine orders. The Department of Labor has now made clear that local shelter-in-place and stay-at-home orders qualify under the statute. So here, locally, our stay-at-home orders would have qualified. FAQ 90 is for those of you who may be running temporary staffing agencies. The Department of Labor makes clear that those agencies are not the ones who are required to provide the paid leave. And on top of that, the size of the temp agency is irrelevant. The test under the statute is the size of the employer and where the employees are placed. And so then if the employees are placed at an employer that has less than 500 employees on the day of placement, that's what triggers the FFCRA. FAQ 91 talks about teleworking. I know Patrick covered that, but it basically makes clear that even if an employee has been teleworking successfully up until now during the stay-at-home order, he or she can still qualify for leave if an illness of a child care provider or a school issue, which is not really important in the summer for most people, but if those are new conditions that otherwise would qualify for leave under the statute, they do apply to employees who are teleworking. The assumption being if you've got to take care of a child full-time, you're not able to do your job even at home. And FAQ 92 talks about documentation that can be required. The employer can only require the employee to identify their symptoms and a date for a test or doctor's appointment. You cannot request further documentation or certification the employee has sought a diagnosis or treatment from a healthcare employer. In other words, even if you suspect the employee is overplaying the sniffles, do not ask for a doctor's note of diagnosis. And that's something I think we heard the other speakers talk about. But let's go to the next provision, which is most pertinent. Next slide, which is this slide here, which is most pertinent, I think, for our seminar today on workplace reopening. There are, as all of our HR personnel attending today know, the FMLA has long had job restoration requirements. When an employee returns from FMLA leave, he or she must be restored to the same job or to a, quote, equivalent job. The employee is not guaranteed the actual job held prior to the leave, and an employee returning from FMLA leave cannot be required to re-qualify for any benefits the employee enjoyed before the leave began. So keep that in mind when thinking about Patrick's advice. The FFCRA is all of that on steroids, and it's probably the main problem with the statute. That is how to restore a lot of employees to work at the same time for probably the first time in your work history. I mean, this is going to be a big test for employers, bringing this many employees back when there might not be the same level of work available to keep all those employees on the payroll. So this is the nightmare scenario everybody's been wondering about. How do you call back an entire workforce or a portion of it in light of COVID? You know, many businesses are not going to look the same. Restaurants may be open, but may not have as many tables. Maybe they won't have any tables at all. Maybe they've been reduced to carry out or takeout service. So in theory, the Department of Labor regulation takes care of this by creating an exception for FLSA leave. Now, I'm going to come back in a minute to FMLA leave, but as I mentioned at the beginning of my remarks, part of the statute's a special provision for paid sick leave under the Fair Labor Standards Act. For that kind of leave, if the employer would have taken employment actions such as layoffs that would have affected the employee at the time of the restoration request by the employee, whether or not they had taken the leave, then there's no guaranteed job restoration. That is, if the employer can prove they would have downsized the workforce, including that employees who's returning's position, then you're not required to restore them to their job. Now, let's talk about the expanded or extended FMLA job restoration provisions. Here, it's just the same old rules as under the FMLA with some exceptions. There's a key employee exception or exemption where the employer can deny job restoration to salaried exempt employees in the top 10% of employees as determined at the time of the leave notice, not when they're asking for restoration of their job. And that's determined by the employee's total earnings divided by weeks worked that year to date. The reason it's determined at the time of the leave notice is obvious: to give everybody an opportunity to plan, including the employee who's taking the leave, considering alternatives of not coming back. Under the FMLA, there's also in the DOL regulations for the FFCRA FMLA leave provision, there's also a small business exception for employers with less than 25 employees. That's spelled out in a regulation at 29 CFR section 826.130B3. I know that's legalese, but I don't have time to cover it in detail. There's also the same exception I just mentioned about the FLSA portion of the statute. That is, if the employer has taken job actions such as a reduction in force, where the employee's job would no longer exist, then you don't have to restore their job. And then finally, there's an exception if the employee took his or her expanded FMLA leave fraudulently. No need to restore those jobs because they shouldn't have taken the leave in the first place. So let's go on to the next slide. I do want to talk briefly about what's going on to enforce the statute, both by the government and by private plaintiffs' lawyers. The Department of Labor's philosophy has been, under the statute, since it went into effect in April, has been to educate employers and employees, not busting their chops. For example, the wage hour administrator made a blog post on May 11th explaining the FFCRA in very simple terms. During the week of May 18th, the Department of Labor put on 3 webinars. Hopefully some of you saw those webinars. But they've also started investigations, and they're trying to see if employers are following the statute. As early as April 23rd, they secured back pay from an employer in Arizona for refusing to pay for sick leave benefits that employees were entitled to under the statute. And since then, the Department of Labor has announced that it has secured back pay from employers in Hawaii, Indiana, Texas, and Maryland, in addition to the one I mentioned in Arizona. That last one in Maryland was on June 8th. But other than those 5 states and those 5 particular agreements that were reached with employers to provide back pay under the FFCRA, I cannot find any other evidence of enforcement actions. And usually the Department of Labor brags about this stuff on its website. So if they're not bragging about it on their website, they're not really gunning to open investigations and secure back wages from employers. I think the general concept right now is to work with employers because everybody's trying to sort through this new world together. Let's go to the next slide. The private plaintiffs' lawyers are probably not going to be so charitable because there's money to be made here. As I mentioned during the April 7th webinar, there are private enforcement provisions in both the Fair Labor Standards Act and the FMLA. So employees can hire a private lawyer to bring either an individual or a class action or collective action under the FLSA under these statutes, which could lead to some big exposure. I think that's where most of the action is going to be. I don't think it's going to be by the U.S. Department of Labor. And as we start seeing these lawsuits being filed, my law firm's keeping track of them. We've been keeping track of every COVID-19 suit of any kind since they first started being filed. There's now almost 3,000 lawsuits relating to COVID-19 around the country. Of those, about 210 have raised labor and employment issues of various sorts. And if we're not talking about mass layoffs under the WARN Act, they're relating in some way to the FFCRA or other concepts of breach of contract or discrimination and retaliation. So that's basically 7% of all lawsuits relating to COVID have been about bringing labor and employment issues in private actions. Of those suits, so far I've seen 17 labor and employment COVID-19 lawsuits filed here in Florida. That's therefore about 8% of all labor and employment COVID cases in the country that have been filed. And if you think those numbers are low, I don't think we should get lulled into a false sense of security. The plaintiffs' lawyers have been slowed down by the virus just like employers and the rest of us have. I think these lawsuits are going to start picking up steam, especially as employers were previously shut down. Now, as employers are opening their work sites, I think you're going to start seeing issues arise like the ones Patrick and Aaron just talked about, and you're going to see lawsuits over them. Basically, these lawsuits raise claims under the whistleblower provisions. For example, the FFCRA allows for lawsuits for retaliation, just as does the Florida Whistleblower Protection Act. We've already seen 3 lawsuits for termination where an employee has alleged in Florida retaliation, either for failure to follow CDC or FDA guidelines or other forms of retaliation. There have been a number of general termination claims, whether it's for supposedly not following the rules or something else that is not protected under the FFCRA. We've seen in Florida general wage class action under the FLSA. That's a claim for unpaid overtime wages. That also includes a claim of retaliation for raising the issue the employer was not following guidelines. There's minimum wage claims and also discrimination and general breach of contract claims. I could say a lot more about these, but the general concept, I think, is this. I think that and I forgot to mention, there was one more lawsuit about, actually multiple cases, about failure to provide PPE and safe working conditions, which doesn't really raise an issue under the FFCRA, but you could have exposure if you're not trying to protect your employees, because you have a duty to provide a safe workplace. I think there's a common theme to all the cases. And assuming that the factual allegations in these cases are true, and I don't know that, there may just be a communication problem underlying a lot of these lawsuits. I think if you are clear with your employees, as Patrick was suggesting, amending your handbook or your postings and making clear what your expectations are and how you're following your legal obligations, I think that goes a long way. If you set clear expectations and document requests for leave, I think that you're going to do a good job trying to insulate yourself from lawsuits. Last slide. In the time allotted, that's all I could do, but I do want to point out we have a variety of resources on my law firm's website about COVID-19 issues under various kinds of laws. I've given you a link here to that, to the Department of Labor FAQs in both English and Spanish, which you may want to consider, maybe even taking part of this, posting it. There's also, DOL has a suggested poster in multiple languages on their website. That was in my April 7th presentation. And then at the bottom, I give you a link to our firm's website where you can take a look at any private lawsuit raising COVID-19 issues, including the ones under the FFCRA. If you want to get into the details of each of the lawsuits, just shoot me an email and I'll give you the password to the password protected portion of the website. And then when we get to the Q&A, I'll answer. One person had a question about taking care of elderly parents under the EFMLA or the FFCRA, and I'll hopefully get a chance to address that. Thank you.
Well, thank you so much, Michael and Aaron and Patrick. And we have certainly received a lot of great information from a legal standpoint that'll really inform what our next steps are in living out, right, in this new normal amid this COVID-19 environment. We've already, experienced and are experiencing an economy that's opening in support of our economic engine here in Florida, while we simultaneously see this war against our unseen but globally felt enemy, I call it, in COVID-19. But it doesn't mean that we lay down and sleep this thing out, but we have to creatively navigate this new normal. You see my hashtag new normal, that's my little slang there. And we have to find a way to safely, and Michael just talked about this, safely conduct the business that keeps our economic engine flowing. So if we can go to the next slide, I will flow through here. And I tell you, we are, there's some assumptions, and I'm going to be speaking with you from the business's perspective, right, as HR. We're talking about reopening businesses, many of which have already opened. I use the phrase repopulation because that's what we're calling it in our higher ed community. We never stopped operations. We never closed. Excuse me, we simply moved nearly 80% of our 11,000 faculty and staff off of the site, if you will. And most of our students moved to remote learning environment. And so our challenge is to bring faculty, staff, and students back to campus, right? Similar to what other organizations are doing across the nation. We have and recommend that all organizations make some assumptions as you begin to do that, keeping in mind the things that you've just heard from my colleagues. First and always, the priority would be health and safety, right? It's our responsibility to make sure that our employees come back to a safe environment. And then, the other actuality is that there is no vaccine. And oftentimes I'm conflicted because we are moving quickly forward as if the hurricane has ended, right? And it has not, but we do have to learn how to live and work safely in this environment. And then, of course, keeping it real, as we do repopulate, right? There is the risk that we will experience a resurgence. You're seeing it now. I think today the numbers I hear are about 5,000 positive cases. Part of that is because we are congregating and we're coming back together. So that's another actuality that we just have to be aware of as we live this thing out. and then think about, what are the protocols for us to identify when we do see that happen into our workplaces, and how are we isolating, and how are we, managing the potential exposures that are happening within our workplaces? What are we doing about that? And then the depopulation plan. I mean, we call it depopulation, which conversely, is the opposite of repopulating. But we need to have in mind what the plan is should we need to go back to that place where we have to shut it all down. So just being thoughtful about what needs to happen next as we live out this the new normal. Next slide, please. So if you've been following the Chamber's HR and Professional Development group for the last 2 years, we've been presenting on and workshopping about the future of work. And guess what? The future has abruptly arrived, right? Who knew then that which was to come would be right now? And this is the Golden Bridge in Vietnam. And it's a beautiful bridge, but as I look at it, to me, it metaphorically depicts our discussion. Like, see us on the right side, talking about the future of work. What's going to be like? What kinds of things can we employ? How can we get ready for that? And then this hand carries us over to the other side, right? We've walked into that future. And so not only is our new normal complicated by the realities of the pandemic that we're seeing a cure for and seeking a cure for, and Patrick alluded to this earlier, but we're also navigating this amidst the racial pandemic that's rewriting history, right? And reshaping our views on what's ailed us as a nation. And both of these pandemics, if you will, are reshaping how we repopulate, how we come back into the workplace. How are we going to do things differently, as we, begin to live and work and entertain and all of those things. So we have a lot of opportunities there to make sure that we view and review what our practices have been. Our president coined the phrase, getting better at being better. And I would like to offer that to you as leaders and members of organizations that are tossed between, how I return to what I've always done, right? And then taking opportunity to make the organizations and the businesses that you lead in, better. What can you do to retool? What kinds of things can you do to create in a different way, a better work environment? So I just wanted to show that picture to you. So we talked about, our attorneys have shared with us some things that are on the legal landscape, but, and I guess I'm echoing and reiterating that, but in a practical sense, really setting expectations. I think Michael talked about that. The things that we're looking at in our organization are delineated here. And so this graphic, it kind of reflects what we're doing and picking up the pieces and trying to organize around the disruption that we've been handed. Even in this, it's still important to set expectations. It's still important to ensure that everyone is on the same page. When you go to Publix today, you're very clear about walking up the aisle one way and coming down the aisle the next, right? That's important. We're making it clear at FIU that you need to wear masks or face coverings rather to enter our campuses. And so those types of things you clarify for your organization and those constituents that you serve and service, and that's important. Leading with listening, that's a common phrase and that's critical in business. We hear that a lot, whether that's within or outside of a pandemic. But at the end of the day, it's the people, right, that are keeping our organizations going and flourishing. So it's important for us to hear what their thoughts are, what are their concerns, how are they, what suggestions do they have? You'd be surprised of how much thought our team members are giving to the very same things that we're grappling with as leaders, and they have so much to offer. So we want to take time to hear them and listen to them. And guess what? It's also important to listen to how they are feeling, right? I can't imagine, we packed so much into 4 months, but people are having, they're experiencing emotions around this. So it's important for us to even check in on them. How are they doing physically? How are they doing mentally? How are they doing emotionally? So listening is so very important. We touched on it earlier. We're phasing in our return here at the university. 11,000 people, we don't want them all to come back at one time, right? So what positions do we need to bring back here right now that are going to be supporting our students that are going to be here and now? And so we're being very careful. Those positions that can work remotely, we would encourage them to continue to do so. Those positions that are working on campus, as they have always done, we are ensuring that they're practicing social distancing. We're ensuring that we're keeping things sanitized and providing the resources for them to keep things sanitized. So those are the phasing is very, very important. And it's important that we communicate those things that we're doing. We amplify those safeguards, because that's what builds confidence and people coming back. You are hearing it all across your organizations. I'm sure there are people that are scared to death to leave their homes. And with all of the legal framework that we have in place, I don't believe that that means that we can only do that. I think as organizations, we can be creative. We can do more. We can add greater levels of comfort where it's possible within your organization to encourage your teams to return and know that they can have confidence in the measures that you put in place to make sure that all will be safe. So you amplify that, you make that, you market that, you let them know the things that you put in place, and then make the accommodations where you can to support and to assist. If there's a role that can continue to work remotely, consider that, because that's going to certainly build confidence in your organization. The other thing is of course, making the spatial requirements in place. We are ensuring that when you do come back, with social distancing. So I may have to stagger my employees. I may have to have shifts. I may have to have one person come in on a Monday and then the next person come in on a Tuesday, and stagger. Be creative around the things that you can do to make sure that your teams feel comfortable returning to that workplace, and then provide the support that's necessary, right? It might be computer support, technical support. It might be PPE physical wear that they may need to have. We have laboratories here. We have food courts here. We've got to do some things differently. We're having to remove tables because we don't want congregation in clustered areas. And so those are things that we're going to have to do to make sure that the community is safe for everyone. So ours is a phased approach to make sure that people feel comfortable in returning here to campus. The next slide, please. So, I think Patrick talked about this too. What are the strategic considerations that we need to make? None of us knew that this was going to happen in this fashion, right? But what's interesting is last year, our board of trustees approved our strategic plan. And within that plan, because at that time we were teetering around maybe 5 to 7% of people sporadically working remotely, nothing formal or structured. Well, in an effort to maximize space, our student body is growing. We propose that we infuse in that strategic plan a plan to move 40% over 5 years, okay, of our employee population to remote work, right? How exciting was that? And in this environment, it was a little difficult, but we got it done. Super excited about that. And we could, we proposed it would be opportunity for space repurposing, for research and student courses, and all these great things. Well, all of a sudden, in like an overnight, we moved 80% of our population to remote work and learning. And who knew, right? So now that we're coming back, so we're saying, okay, what is it that we've learned from that? What is it that we experienced? And as much as it was dreadful in terms of having this disease come to us in the manner that it did, what are the silver linings? And I think it was Patrick that mentioned it earlier. We've identified that several of our employees are far more productive in this circumstance than they were even with the, in the structured environment. So I'm saying that to say, consider the lessons learned. What are the codependencies as you bring people back, right? If in our case, if you're facing students and supporting students and students are going to be back, then maybe that's the group that you bring back first. If the researchers are doing groundbreaking research that is time sensitive, maybe you bring them back first, right? But take advantage of the momentum that you've gained over this period of time when you've had to work remotely and other things that you've had to do. We talked about staggering and compressing schedules. Maybe you have your employees working the first part of the week and then stagger schedules around that. And we had instances, and this might answer one of the questions about talent. We've had opportunity to repurpose talent. Maybe your role, because of the remote situation, took work away from you. We have something here that we call talent share. So we've been able to move talent around so that we didn't have to do layoffs. We could support people and continue to keep people in an employed circumstance versus doing a layoff. So there were so many things that we gained from this awful experience of COVID-19, and I'm just wanting to suggest that as you consider what the next normal is going to look like, that you don't make it what you've always made it. It doesn't have to be what it's always been. Okay, thank you. Next slide. And I did want to share this as it relates to, remote work. We had done, Mercer had done this study, but we had also done some internal surveys around how our employees were doing remotely. And it was interesting that this survey aligns so closely with the information that we've learned and gathered in our own. And we were able to see how individuals could be as successful in a remote work environment. The one thing that we didn't evaluate or survey in our survey was the mental health piece. And there again, of all the things that this has really taxed, it has been the emotion and mental health of our employees. So we want to keep that in mind. Yes, productivity has increased. Yes, individuals have been able to deal with home life during the workday more favorably. Yes, we've been able to communicate and collaborate far more than maybe we had prior to this. But be mindful that the negative outcomes associated with emotions is very, very important. So we want to keep that in mind as we take care of our employees, who take care of our organizations and make them the success that they are. And so I know that we're running out of time. I think we can go to my next slide, which says, do your part, whatever that is. Control what you can control to mitigate risk, because this is actually beyond our organization. This has everything to do with the globe that we share, right? And in this case, this really is a life or death situation, right? So what we do in terms of physical distancing, in terms of taking care of our personal hygiene, in terms of limiting our visits and accessibility to others, right? All of these things are things that we can control. Right now, we don't have a vaccine, so we can't control that. But what we can control is those things that concern what we can do. Pre-schedule the meetings. Maybe as we come back, we'll have people come in by appointment only, and we can make sure that those meetings don't last more than 15 minutes and that we're certainly socially distanced and we can protect one another in this part. So I want to thank you all, and I want to turn this back over to Patrick to answer any questions that you all might have. And we thank you again so much for giving us this part of your afternoon.
Well, thank you, EK. I think we're going to try to really just jump into these questions because we are running out of time, but we do want to answer them. The first question, I think, is for me. It's from Joanne, and asking whether we recommend having just one policy that addressed the various issues that I had talked about during my presentation, or amending each of the policies in the handbook. And frankly, it's both, really. There are issues, or there are policy requirements that deal with the paid leave, the the First Family Act leave requirements that are not necessarily a permanent change. I mean, Michael can clarify this, but they're going to sunset at the end of the year. And so I don't necessarily recommend that you permanently change your handbook for those. But for some of the other ones, for example, remote work or your job descriptions, those are certainly something that you want to individually amend in the interim.
Can I just add to that, Patrick? What we did here is we created a policy that we call COVID-19 emergency. And so it's going to live as long as these provisions live. And we added to that some of the additional provisions that we as a university provided. So for us, it worked, and it kept us from touching our other policies that could remain intact.
Great. A next question that came up is, how do you, and this, I think this one is for Aaron. Aaron, you talked about refusal to come back to work, or individuals who are concerned about coming back to work. But what about an individual who doesn't want to wear a mask and refuses to wear a mask for whatever reason? What would you recommend in terms of dealing with that individual?
So obviously, to the extent that you've actually created the policy that Patrick or Alpanye discussed, in which you've identified that as part of the workspace, you're requiring people in common areas to wear masks, the refusal to wear a mask is in itself maybe a violation of that policy, just like the refusal for people to wear shoes, right? We have various businesses where people say, you can't come in if you don't wear shoes. An employer can require certain types of dress and require certain types of activity. Obviously, you have to balance that with, as Patrick pointed out, religious accommodations, you know, and the like. But the fact of the matter is that masks can be worn. I want to point out that you know, when we talked about this, having a policy which is communicated, and that's one of the things everybody has talked about, is very important. You can't point to a policy that you haven't told people about. So as long as you've told people about it and been clear about it, people coming back to work must know that they are coming back to work under a set of guidelines, like the security procedures, the protocol for health, and the screening. So in my view, if somebody refuses to wear a mask, it's just like, you know, that case we had out in California where somebody refused to wear clothing for attending meetings. They got tagged for, you know, more than $18 million for violating not only, you know, harassment laws, but also actually for violating the company's policy about the way business was supposed to be conducted. So that would be my answer to that, Patrick.
The next question I think is for you, Mike. Rasha asked, you know, there's a lot of the leave laws talk about caring for your child whose child care is either closed or school is closed, but what about dependent adults who normally go to adult daycare? What do you advise in dealing with an employee that has that sort of responsibility, since they can no longer take them to adult daycare?
Well, I saw that question come in. I thought it was very interesting. The person who submitted that question is correct. The FFCRA does not address this. I think it's a straight up FMLA question. Under the FMLA, if you have responsibility to care for an elderly parent, you can claim FMLA leave if they have a serious medical health issue. But the FFCRA just doesn't apply here. I mean, the fact that you cannot get elder care the same as you might have a problem getting child care doesn't create a new issue. It's just there's no new leave provisions for it in this statute. And as I read the guidance, unless that person is a child or somebody for whom you have child care responsibilities, either biologically or by law, the new statute just doesn't cover this.
Thanks. The next question that comes in deals with someone who was on FMLA but then has been since cleared to return to work, and the business is about to open, but the position that this particular returning employee has is not expected to be recalled. Can that employee be terminated? Either one of you might want to take that.
You kind of answered the question, I think. If it could be documented that the position is not available and otherwise would have been eliminated because of, let's say, lack of demand, lack of customer traffic, whatever, that's the end of it. I would just suggest making sure this is documented, make sure it's not post hoc, so that you can survive a challenge if there is a challenge.
Yeah, I mean, I agree with you. I think the key there is otherwise being terminated, right? So, I mean, if this individual is just like everyone else, meaning waiting to come back, then you want to treat that individual just like you did everyone else. If you terminated everyone who can't come back, then obviously you can go ahead and terminate for the same reasons.
Yeah.
Let's go to the next question. What if an employee is, doesn't show symptoms, gets tested and is told to quarantine? Oh, I'm sorry, is tested and is told to quarantine but doesn't do so. Can you terminate this individual for essentially coming in and infecting the rest of the workforce?
Well, I don't understand. How would it come up? How would you learn? It depends on how the employer learned.
Well, I'd also say, and again, we haven't seen guidance from this from any of the agencies, but I would go back to the measles outbreak we had a year and a half ago, and there was guidance from OSHA that if somebody had the measles and was required to quarantine and refused to quarantine and tried to come back to the workplace, then OSHA indicated that you could bar the person from the workplace. And under local laws, I don't think we have these cases here in Florida, but in other parts of the country like North Carolina and California, people were terminated for wanting to work while they still had the measles. When I say still had the measles, meaning their doctors had indicated that they were still carriers and potentially could infect other people. Not that they had been diagnosed with measles, gone home, been quarantined, and then returned to work because the doctor had indicated they could return to work. We're only talking about somebody who, after being diagnosed with measles, decided they didn't want to quarantine. There were cases in California where people were allowed to terminate that employee. So I'm not sure whether or not OSHA will take the same view with COVID, but that's the guide. I mean, that's available out there.
Yeah, and I think, this person clarified the employee disclosed after he received a positive result, but certainly not before coming back to work knowing that he was positive. And so I do think in that situation, similarly, that he's violating your policy to disclose this information, and you're making the workplace unsafe. And so certainly you have grounds to terminate, in my mind.
Agreed.
Last question is, do we need an employee's permission to report their name and positive results to the health department? I guess a government agency that's handling this in terms of a health department.
Yeah. I'm not aware of anything that allows you to report a name without the employee's consent. It's a HIPAA problem.
Although I think if you have OSHA requires you to provide the name and the social security number of people that could be exposed. So the OSHA guidance in this case is if you've made a determination that there's a workplace exposure, then you have to identify the people who've been exposed by their name and social security number, and the steps that you're taking. But that's different after you've run through the sort of checklist and some type of flow chart to determine whether you actually have a reporting incident.
Well, I think that answers everyone's questions, and we have gone over. So I want to quickly just go into towards the end here, and I also want to make sure to remind everyone that after our webinar, immediately after, and in fact it may have started already, there's a webinar being put together by the South Florida Business Council. They're holding a webinar in which the chair of the state university system is going to be discussing their plans, the state universities' plans to reopen, and I think it's a very informative and certainly something that a lot of people are thinking about as we're approaching the fall. And so that again, quickly, it immediately follows ours. But now, I hope you enjoyed our presentation. I want to thank the panelists. Michael and Aaron have been really active and have helped EK and I in terms of the committee, and they've always answered the call to provide us really valuable information to our HR community. We're lucky to have such experts available to us. And as always, EK and I want to thank Stephanie Parra for her hard work and really rallying us to make us all look good. Her hard work is very much appreciated, and certainly we wouldn't be able to do this without her. Thanks again for attending, and I hope everyone enjoyed it. Yes, there will be a recording that's available to everyone, and surely if you want I think a lot of you asked whether or not we would make our slides available, and I think each of the panelists would be more than happy to do so. Thanks again, everyone.
Thank you. Take care. Have a good day.